over the Negotiable Instrument Act of 1881 as amended in 1882, otherwise known as the Bill of Exchange Act. This is the Canadian version, but there is what is known in law as the law of the mother country. By drawer, 169.1. A check may be crossed generally or specially by the drawer, by holder. 2. Where a check is uncrossed, the holder may cross it generally or specially. Varying. 3. Where a check is crossed generally, the holder may cross it specially. Words may be added. 4. Where a check is crossed generally or specially, the holder may add the words not negotiable. By bank for collection. 5. Where a check is crossed specially, the bank to which it is crossed may again cross it specially to another bank for collection. This is why on my negotiable instruments I like to write, done in good faith, with clean hands, with good conscience, for good reason, given for a patent right, for collection, pay to bearer, changing, crossing. Where an uncrossed check or a check crossed generally is sent to a bank for collection, it may cross it specially to itself. Uncrossing. 7. A cross check may be reopened or uncrossed by the drawer writing between the traverse lines the word pay cash and initialing the same. Anytime we're going to alter something, ladies and gentlemen, we're always going to initial it. That goes for every contract. We learn this stuff in grade school. If you make a mistake and you can't erase it, line through it, initial it, date it, move on. Material part. 171. A crossing authorized by this act is a material part of the check. Altering crossing. 2. It is not lawful for any person to obliterate or, except as authorized by this act, to add to or alter the crossing. Crossed to more than one bank. 171. Where a check crossed specially to more than one bank, except when crossed to another bank as agent for collection, the bank on which it is drawn shall refuse payment thereof. Liability for improper payment. 172. 1. Subject to subsection 2, where the bank on which a check crossed pays a check crossed generally otherwise than to a bank, or if crossed specially otherwise than to the bank to which it is crossed, or to the bank acting as its agent for collection, it is liable to the true owner of the check for any loss he sustains owing to the check having been so paid. Payment in good faith and without negligence. Here we go. Good faith. We're always doing everything in good faith. 2. Where a check is presented for payment that does not at the time of the presentment appear to be crossed, or to have had a crossing that has been obliterated, or to have been added to or altered otherwise than as authorized by this act, the bank paying the check in good faith and without negligence shall not be responsible or incur any liability, nor shall the payment be questioned by reason of the check having been crossed, or of the crossing having been obliterated, or having been added to or altered otherwise than as authorized by this act, and of payment having been made otherwise than to a bank or to the bank to which the check is or was crossed, or to the bank acting as its agent for collection, as the case may be. Protection in such case. 173. Where the bank on which a crossed check is drawn in good faith and without negligence pays it, if crossed generally, to a bank, or if crossed specially to the bank to which it is crossed, or to a bank acting as its agent for collection, the bank paying the check, and if the check has come into the hands of the payee, the drawer shall respectively be entitled to the same rights and be placed in the same position as if payment of the check had been made to the true owner thereof. Not negotiable. Cross. 174. where a person takes a cross check that bears on it the words not negotiable, he does not have and is not capable of giving a better title to the check than the person from whom he took it had. Customer without title. 175. Where a bank, in good faith and without negligence, key words, without negligence, receives for a customer payment of a check crossed generally or specially to itself, and the customer has no title or a defective title thereto, the bank does not incur any liability to the true owner of the check by reason only of having received that payment. Now we're going to get into the good shit right here. Part 4, promissory notes. Definition 176.1. A promissory note is an unconditional promise in writing made by one person to another person, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. Endorsed by maker. 2. An instrument in the form of a note payable to the maker's order is not a note within the meaning of this section unless it is endorsed by the maker. Pledge of collateral security. 3. A note is not invalid by reason only that it contains also a pledge of collateral security with authority to sell or dispose thereof. Inland notes. 177. A note that is, or on the face of it purports to be, both made and payable within Canada is an inland note. The same applies if you're doing the note in the United States, okay, or in Indonesia. It's considered an inland note. If you're doing business over in India, then it's an inland note over in India when you're doing the business over there. If you're doing business here in the United States and you're signing that note here in the United States, then it's an inland note as far as the United States is concerned. If you're doing it in Canada, the same thing applies, okay? Foreign note. 2. Any other note is a foreign note. Delivery. 178. A note is, I always struggle with this fucking word, inchoate and incomplete until delivery thereof to the payee or bearer. Joint and several liability. 179.1. A note may be made by two or more makers, and they may be liable thereon jointly or jointly and severally, according to its tenor. Individual promise. 2. Where a note bears the words, I promise to pay, and is signed by two or more persons, it is deemed to be their joint and several note. Demand note presentment. 180. 1. Where a note payable on demand has been endorsed, it must be presented for payment within a reasonable time of the endorsement. Reasonable time. 2. In determining what is reasonable time, regard shall be had to the nature of the instrument, the usage of the trade, and the facts of the particular case. Endorser discharged. 181. Where a note payable on demand that has been endorsed is not presented for payment within a reasonable time, the endorser is discharged, but if it has, with the assent of the endorser, been delivered as a collateral or continuing security, it need not be presented for payment so long as it is held as such security. Not deemed overdue. 182. Where a note payable on demand is negotiated, it is not deemed to be overdue for the purpose of affecting the holder with defects of title of which he had no notice, by reason that it appears that a reasonable time for presenting it for payment has elapsed since its issue. Presentment at particular place. 183. Where a note is, in the body of it, made payable at a particular place, it must be presented for payment at that place. Liability of the maker. 2. In the case described in subsection 1, the maker is not discharged by the omission to present the note for payment on the day that it matures, but if any suit or action is instituted thereon against him before presentation, the cost thereof are in the discretion of the court. Note payable generally. 3. When no place of payment is specified in the body of the note, presentment for payment is not necessary in order to render the maker liable. Liability of endorser. 184. 1. Presentment for payment is necessary in order to render the endorser of a note liable. Presentment at particular place. 2. Where a note is, in the body of it, made payable at a particular place, presentment at that place is necessary in order to render an endorser liable. Presentment elsewhere. 3. When a place of payment is indicated by way of memorandum only, all right? Presentment at that place is sufficient to render the endorser liable, but a presentment to the maker elsewhere is sufficient in other respects shall also suffice. Effect of being maker. 185. The maker of a note, by making it, A, engages that he will pay it according to its tenor, and B, is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. Application of Act to notes. 186. 1. Subject to this part, and except as provided by this section, the provision of this Act relating to bills apply, with such modifications as the circumstance require, to notes. Terms corresponding. 2. In the application of the provisions of this Act relating to bills being bills of exchange, the maker of a note shall be deemed to correspond with the acceptor of a bill of exchange, and the first endorser of a note, promissory note, shall be deemed to correspond with the drawer of an accepted bill of exchange, payable to the drawer's order. Provisions inapplicable. 3. The provisions of this Act with respect to bills of exchange, and relating to A, presentment for acceptance, B, acceptance, C, acceptance under protest, and D, bills of exchange in a set, do not apply to notes. Protest of foreign notes. 187. Where a foreign note, promissory note, is dishonored, protest thereof is unnecessary except for the preservation of the liabilities of endorser. Part 5. This is my favorite part right here, and you're going to see why. This is what nobody's telling you about. Nobody's squawking and talking about consumer bills and consumer notes, okay? And this is important. And you're not going to find it in the UCC, because the UCC is Uniform Commercial Code. They're not going to be telling you about consumer bills and consumer notes, okay? They want you engaged in commerce. See, you go to a bank and you say, I want to start up a deposit account. And they'll convert that deposit account into a checking account with a small little bit of interest. And the reason they do that is so now they can say you're engaged in commerce, you're making an income, and it's a taxable event, and you're engaged in commerce. Okay? You want to prevent that from happening by telling them, no. I don't want my deposit account converted into a fucking checking account, you asshats. I want you to do exactly what the fuck I tell you. I want a deposit account. Nothing more, nothing less. A non-interest bearing deposit account, okay? I don't want to write checks out of it. I don't want to do any of that shit out of it. I just want a non-interest bearing deposit account, okay? Definition. 188 in this part. Consumer purchase means a purchase other than a cash purchase, okay? Check it out. Other than a cash purchase of goods or services, or an agreement to purchase goods or services. Not a bad idea. A, by an individual other than for resale or for use in the course of his business. Right there. This is quintessential. It's key. It's a key element. Ladies and gentlemen, in the United States, when you're doing something and it's for private household consumer goods, ladies and gentlemen, that is the primary obligation of the United States. Okay, you're a preferred stockholder. That's what the birth certificate proves. It proves that not only are you a preferred stockholder, you're a holder in due course. You have also in your hands with the birth certificate is proof of power of attorney per proclamation issued by the President of the United States. Okay, and after 1933, all the proclamations heretofore and hereafter are absolutely binding. All right, so you just acknowledge and accept the proclamations, bring forward your warehouse receipt, the bill of lading, the birth certificate, whatever the fuck you want to call it. Know that you're the holder in due course. You have evidence that you are the beneficiary of said document, and you have special drawing rights that are security obligations of the United States. Okay, Canada may be a little bit different, but it pretty much goes to say it's all the same. Profession of calling, and B, from a person who is engaged in the business of selling or providing those goods or services. Goods means any article that is or may be the subject of trade or commerce. Now, this is very important. When you look up Title 15, subsection 1, subpart 1 in the United States Code, they will have commerce lit up in blue, which means you can click on it and it will tell you what it is. They never highlight trade. You want to know why? They don't want to show you the private side, okay? If they actually gave you a definition for trade, nobody'd be doing this shit, all right? You'd all realize that you're engaged in trade. So when they don't highlight certain words, but they highlight others and they'll give you a definition, it's because they intend to keep you in this realm, and you'll stay away from this because you don't know what it means. This is private, ladies and gentlemen. Trade is private. Commerce is taxable. Trade is not. Barter and trade is not taxable. And I can prove that. I had a buddy once buy a square box Chevy truck for a couple pounds of silver, okay? And when he went to the courthouse to register it, they said, well, what did you pay for it? And he said, I give a couple pounds of silver. And they said, silver what? Like silverware? And he goes, no, a couple pounds of silver. She said, well, what was that worth in dollars? He says, I don't have any idea. I just gave him a couple chunks of silver. That's what I gave him. That was a negotiation. It was an even exchange of fair trade. She says, well, I don't know if I can allow you to register this vehicle that way. Maybe we'll register it as a gift. And in doing so, he would pay more in taxes than if he'd have paid a few $100s for it, right? And so he said, no, I'm not going to allow you to do that, because then I would have to perjure myself and tell you that I spent X amount of fiat to ascertain it, making it a commercial transaction. That is not what happened, and I refuse to do that. So she said, well, I'm going to have to get a hold of the county attorney and find out what we should do in this instance. And so she called up the county attorney, and the county attorney said, well, what did he do exactly? She said, he gave him a couple pounds of silver. He said, well, what was it worth? He says, well, he doesn't know what it was worth. It was just worth a couple pounds of silver, the truck for the silver. And she says, I don't know how to register it and tax it because there's no dollar amount. And the prosecuting attorney said, just give him the registration. So they just gave it to him. Okay, they gifted it to him for nothing because there's nothing to be taxed. Now, in hindsight, knowing what I know, he never even had an obligation to register his automobile. He could have recorded it on public record, claimed it as his own, and never registered it at all. But anyway, needless to say, you have to pay attention to these things. There's a difference between trade and commerce, all right? Or this word right here, this audible word, or wouldn't be there. But does not include land or any interest therein. Purchaser means the individual by whom a consumer purchases is made. Consumer purchase is made. Seller means the person from whom a consumer purchase is made. Services includes repairs and improvements. Consumer bill. This would be a consumer bill of exchange. 189. 1. A consumer bill of exchange is a bill of exchange issued in respect of a consumer purchase and on which the purchaser or any person signing to accommodate the purchaser is liable as a party, but does not include A, a check that is dated the date of its issue or prior thereto, or at the time it is issued, is post-dated not more than 30 days, or B, a bill of exchange that 1. Would be a check within the meaning of Section 165, but for the fact that the party on which it is drawn is a financial institution. Proclamation 2039, ladies and gentlemen. You are a financial institution per the proclamation. Proclamation 2039. Other than a bank that, as part of its business, accepts money on deposit from members of the public and honors any such bill directed to be paid out of any such deposit to the extent of the amount of the deposit, and 2, is dated the date of its issue or prior thereto, or at the time it is issued is post-dated not more than 30 days. Consumer note. This would be a consumer promissory note. 2, a consumer note is a promissory note. A, issued in respect of a consumer purchase, and B, on which the purchaser of any one signing to accommodate him is liable as a party. Presumption as to issue. 3, without limiting or restricting the circumstances in which, for the purpose of this part, a bill of exchange or a promissory note shall be considered to be issued in respect of a consumer purchase, a bill of exchange or a promissory note shall be conclusively presumed to be so issued if A, the consideration for its issue was the lending or advancing of money or other valuable security by a person other than the seller in order to enable the purchaser to make the consumer purchase. Here in the States, ladies and gentlemen, you're giving a credit application with a promissory note, and we're forgetting one other thing we got to give them to prove that we have special drawing rights and that we are the holder in due course, and that all our obligations are obligations of the United States. They're security obligations of the United States. All our notes, drafts, bills of exchange, bankers' acceptance, trade acceptances. You want to know the one thing everybody's forgetting to give them? A birth certificate. Give them the warehouse receipt. It's right there in the 73rd Congress. You have to give them the application, the promissory note, and the receipt. And then you want to create a bill of lading for everything that you're giving to your in your exchange for your private household consumer goods. Remember, you're not engaged in commerce, so it's non-taxable, okay? So long as it's not engaged in commerce, it's not taxable. And B, the seller and the person who lent or advanced the money or other valuable security where, at the time the bill or note was issued, not dealing with each other at arm's length within the meaning of the Income Tax Act. Well, surprise, surprise, the United States and Canada are exactly the fucking same, all right? When it's engaged in commerce, there's an income tax, okay? When it's not commerce, there is no tax, all right? Americans aren't responsible for paying any taxes on the private household consumer goods, period. End of story. Not only that, Article 1, Section 10, Clause 1, the United States Constitution, no state shall coin anything other than a gold and silver coin for the payment of a debt, okay? For the tendering of a payment of a debt. So, with that said, acts don't repeal, they don't amend, and they don't abolish the Constitution. The Constitution's still there, ladies and gentlemen. You just got to learn how to assert your rights and invoke Article 1, Section 10, Clause 1. Now, that being said, Article 1, Section 10, Clause 1 also says the government does not have the right to interfere with contract or impair the obligation of contract. That's why you're getting them to sign all the notes first, all the documentation first, before you leave their building, and then you go back through the contract and you cross out what doesn't benefit you, you add what needs to be added. Maybe you're giving specific instructions on how to negotiate the instrument with a Federal Reserve agent or at the Federal Reserve discount window to be negotiated at the Treasury so the comptroller of the currency can extend Federal Reserve notes, or maybe you're simply putting them on notice to go ahead and terminate the note. Okay? And you're going to do an acknowledgement and acceptance of the warranty deed, the grant deed, the joint tenancy deed, the bill of sale, whatever it is. Okay. Application of act to consumer bills and notes, consumer bills of exchange and promissory notes. The application of act to consumer bills of exchange and consumer promissory notes. 4. Except as otherwise provided in this part, the provisions of this act applicable to bills, bills of exchange, and checks apply, with such modifications as the circumstances require, to consumer bills, and those applicable to promissory notes apply to consumer notes, with such modifications as the circumstances require. Consumer bill, bill of exchange, or note, consumer promissory note, to be marked 190. Listen, ain't nobody fucking telling you this shit, but I'm gonna give it to you right here. All right, pay attention. 190 is fucking crystal clear. Every consumer bill, bill of exchange, that is a consumer bill of exchange, or consumer promissory note, shall be prominently and legibly marked on its face with the words consumer purchase right there. And they've got quotation marks around it. Ladies and gentlemen, I have found that anytime in the code they've got something in quotation marks, they are drawing your attention to it. Okay? So anytime you're doing anything that is a consumer purchase and not for your business that you intend to write off on taxes, and you're not doing a commercial thing, you're doing an even exchange fair trade, paper for paper, the thing that you're acquiring has no bearing, because if you read the 73rd Congress, the application, the tender, and the receipt is actually the security, ladies and gentlemen. Before or at the time when the instrument is signed. So again, you've got to do it before or at the time the instrument is signed. This isn't something you can allonge later because you think it benefits you. You have to knowingly, willingly, and intentionally know what you're doing when you walk in there, and make sure that the contract or the promissory note or the bill of exchange, whatever you're doing, says consumer purchase. All right. And your credit application is for a consumer credit transaction. Okay. Before or at the time when the instrument is signed by the purchaser or by any person signing to accommodate the purchaser. Effect where not marked. Here's where the consequence is for not listening. 2. A consumer bill of exchange or consumer promissory note that is not marked as required by this section is void, except in the hands of a holder in due course, without notice that the bill of exchange or promissory note is a consumer bill of exchange or a consumer promissory note, or except as against a drawee without that notice. So important. All right, ladies and gentlemen, that concludes. There's one last part here. All right. In the consumer bill of exchange, in the Negotiable Instruments Act of 1881, amended as amended in 1882, otherwise known as the Bill of Exchange Act. In the Canadian layout of this act, they have noting for non-acceptance. They lay it out for you exactly how it should be laid out. Your protest, look, they give you the fucking shit. This is like corpus juris secundum here. They're giving you fucking templates, for fuck's sake. This is paint by numbers. A monkey at the zoo could do this shit. Protest for non-acceptance or non-payment of a bill payable at a stated place. Now, you have to do a little research into the United States, but I'm venturing to say it's going to be similar, okay? The reason that we went through this first is next we're going to go through the UCC, and I wanted you to have a foundation as to how the UCC became the way it is, why it is the way it is, and by understanding the Negotiable Instrument Act of 1881 as amended in 1882, you will soon see how the UCC ties into it. All right. But the UCC, again, is Uniform Commercial Code, and it's for commerce. Form 4, protest for non-payment of a bill noted but not protested, non-acceptance. And they tell you exactly what you need to do for that. Form 5, protest of non-payment of a note payable generally. All right, so this is if you're going to do a protest. Okay, and this is exactly how you do it right here. They lay it all out for you. Real short, simple and sweet, one fucking paragraph. Hurrah, hurrah. Form 6, protest for non-payment of a note payable at a stated place. Form 7, notarial notice of a noting or of a protest for non-acceptance or of a protest for non-payment of a bill. I give it to you right here. There it is. Can't fuck it up. You can't fuck it up. It's there verbatim, word for word. Look, they even use the same fucking peso symbol. It's a different ISO or iOS code for the Canadian currency, but still the same peso symbol. Form 8, notarial notice of protest for non-payment of a note. Form 9, notarial service of notarial service of notice of a protest for non-acceptance or non-payment of a bill of exchange, or promissory note. Form 10, protest by a justice of the peace where there is no notary for non-acceptance of a bill of exchange or non-payment of a bill of exchange or promissory note. And that concludes the Negotiable Instruments Act of 1881 as amended in 1882, and also known as the Bill of Exchange Act. All right. And when we come back, we'll be going over the UCC. We'll make you guys fucking lethal. I'm telling you what, we're going to make you fucking lethal.